today for the third webinar of our new staff training series. Today's topic will be From Outreach to Move-In. Before we get started, just a couple of reminders. Everybody's lines will be muted throughout this call. You're welcome to enter questions through the question box at any time. And we will have time at the end for a question and answer session. And if you prefer to ask your question verbally, you can go ahead and use the raise your hand function, and we will unmute your line individually at that time. So without further ado, I'm going to turn it over to Kate Moore of True Casa Consulting to take us through the presentation. Kate?
Thank you, Ellen. Welcome, everybody, to the Section 811 Project Rental Assistance Program Outreach to Application and Move-In webinar. This webinar is the third in a series of webinars to provide new staff to the Section 811 PRA program targeted information about the program. So let's review the agenda for today. First, we'll review the webinar training series. But the main focus of today is to review and discuss the steps it takes to get from outreaching to potential 811 PRA tenants all the way to move-in of a tenant. So we're going to be reviewing some of the important elements along the way, including the interagency partnership agreement, the outreach and referral process, outreach and how it relates to the affirmative fair housing marketing plan. We'll talk about tenant eligibility, waiting list management, referral to an owner, and finally we'll talk about a successful move-in and the processes of revolving that. For those who might not have participated in any of the webinars to date regarding the 811 PRA program, I want to review some basic information. The 811 PRA program is a long-term project-based subsidized housing for extremely low-income people with disabilities. Funds were awarded to state housing agencies from HUD who administer the program in partnership with their state services or Medicaid agency. If you are new to the program, there are a couple terms you will hear. One is grantee, which is the state housing agency who is awarded the Section 811 PRA grant. The next is 811 PRA, sometimes referred to as 811, sometimes referred to as PRA. These are both shorthand for the Section 811 Project Rental Assistance Program. So let's review the training series. So Section 811 has been around long enough that some states have had staff turnover or other staff might be newly assigned to the 811 PRA program. This webinar series is designed to provide support for those new staff as well as other staff members who may want a refresher or an opportunity to learn more about the 811 PRA program. All of the webinars will be available on the Section 811 PRA website on the HUD Exchange. So this series includes 8 webinars. The first provided an overview of the 811 PRA program. The second discussed methods for identification of units for the program. The third webinar is today and will focus on outreach to potential 811 tenants and review all the steps of the program until a tenant moves into a unit. The fourth webinar focuses on ongoing daily responsibilities of the grantee, such as budget tracking and reporting. The fifth webinar will be by Blueprint Solutions and will dive deeper into HUD systems. The sixth webinar will discuss how the grantee can help owners meet their responsibilities. And the seventh webinar will focus on supporting tenants to be successful. And the eighth webinar right now is open for discussion and interest of the participants. So next we're going to discuss the Interagency Partnership Agreement. The 811 PRA program is a unique program because it requires participation and partnership between agencies and organizations who might not typically work together. So the U.S. Department of Housing and Urban Development, or HUD, who regulates the 811 PRA program, gives states the flexibility to determine who will be responsible for the roles and responsibilities of the program, but ask states to put them in writing in a contract between the state housing agency and the state Medicaid agency, and often the state human service agency. This document is called the Interagency Partnership Agreement. The Interagency Agreement is specific and unique to each state. A lot goes into creating this document because it outlines the roles and responsibilities of all the partner agencies in the program. The core aspects of the interagency agreement include the target population to be served, outreach and referral methods for reaching the target population, and supportive service commitments for the tenants. The interagency agreement was originally created when a state applied for funds from HUD, but will need to be amended as changes are made to the state's program. Keep in mind, if a target population changes, the grantee should notify HUD. So next, we're going to discuss outreach and application. Some key elements for making the PRA program work is for everyone to fully understand their roles and responsibilities in the program. Building up partnerships, especially if they're new to a state system, can take time and commitment from all partners. TAC has found that states with successful 811 programs, as well as other types of housing and services partnerships, depend on regular meetings and communications between state agencies. Some examples of this include monthly meetings between all the state agency partners. Most states find that they also need specific regular calls or meetings to discuss ongoing program elements, such as managing referrals to a property's waiting list or supporting a tenant after move-in. As a potential PRA tenant moves through the process from outreach to move-in, many tasks are handed off between the grantee, the housing agency, the service providers, or other entities. When entities don't understand the process or their roles, it can take longer than necessary to refer someone to a unit. As a result, the owner may move on to fill the unit with someone who is not a PRA tenant, or the applicant may fall through the cracks. This is what we all want to avoid. This is hard work. Staff turnover happens, which requires bringing new staff up to speed. States need to be willing to try new things and to support each other and keep at it. So there are 3 documents that impact outreach and referral for the 811 program. As discussed earlier, this includes the Interagency Partnership Agreement. There are 2 additional documents required for the program that we will discuss as well. It includes the Affirmative Fair Housing Marketing Plan and the PRA Tenant Selection Plan. So first, let's review the Affirmative Fair Housing Marketing Plan. The plan must be on the prescribed HUD form, which is listed here, 92243-PRA. This is a document that is a responsibility of the state housing agency, but will be completed in collaboration with the state service agency. The document is not required to be submitted and approved by HUD, but must be completed prior to the start of outreach for the program and kept on file at the state housing agency. The plan includes how the state program will be non-discriminatory in outreach and other activities. It describes how the program will be least likely, it describes how the program will reach least likely to apply. Examples might be persons with communication disabilities or persons with limited English proficiency. And now I'm going to show you what this form looks like. So this is that form. You can find this form on the HUD Exchange 811 PRA website. And if your state has not worked on this, or you have questions about it, you can reach out, your grantee can reach out to their technical assistance lead through TAC. So this is what it looks like, and you can see, you know, you need to describe the outreach that's performed and who should approve correspondence, you know, who's the contact, and it lists who's least likely to apply. All right, so let's talk about the PRA Tenant Selection Plan. So this is a document that must be created and kept on file and made available to the public. It outlines the selection criteria of the program. This differs from the Property Tenant Selection Plan. So the grantee is one type, grantee PRA Tenant Selection Plan is one tenant selection plan. The Property Tenant Selection Plan screens the applicant but does not select. A household who has been selected by the PRA Tenant Selection Plan might be rejected by a Property Tenant Selection Plan. This does not mean that they are no longer eligible for the PRA program, because they can be referred to another property. So elements of the grantee tenant selection plan include a non-discrimination policy, outreach procedures, eligibility requirements, your application process, your waiting list procedures, occupancy standards, and referrals to owners. So next, we're going to discuss tenant eligibility for the program. So let's review the difference between the eligibility requirements of the person in the target population versus the entire household that includes the person in the target population. So the 811 PRA program requires states to create a target population for their program. Some states, for instance, have targeted their program to those persons participating in the Money Follows the Person program, or other states have chosen, for instance, those experiencing homelessness. In addition to being a member of the target population, HUD requires that the target population be a person that is at least 18 years of age and under the age of 62, that they have a disability, that they be eligible for community-based long-term care services as provided through Medicaid waivers, Medicaid state plan options, comparable state-funded services, or other appropriate services. So sometimes the person in the target population has additional people they want to include in their household for the program. Only one person in the household needs to meet the definition of the target population. However, the combined members of the household must meet the following. They must combined be extremely low income as a household, which means that they have to be at or below 30% of area median family income. Okay, so now somebody has been determined that they're eligible, and so there are some ongoing tenant eligibility for you to know about. So once somebody becomes a tenant, they no longer have to meet the initial eligibility requirements, but there are some limited requirements the grantee must keep an eye on. The household income can increase above 30% area median income after occupancy. A family's eligibility for housing assistance payments, which means their assistance through the PRA program, continues until the total tenant payment equals the contract rent plus any utility allowance. So in addition, the household member who qualified as a member of the target population can refuse and no longer qualify for eligible long-term services and support. So that household member, if that happens, can still receive PRA assistance. The household member who qualified for the target population can also become over the age of 62. If the household member who originally met the qualifications of the target population moves out of the unit, there are some options. The remaining members of the household can stay in the unit and pay market rent. So that means that essentially that unit will no longer receive the subsidy from the 811 PRA program. If the remaining household includes a member who meets the HUD PRA definition for a person with disability, that household can continue to receive the 811 PRA subsidy. All right, so you've determined that they're eligible, and now that person is on the waiting list. We're going to talk about waiting list management. So one of the important roles that is outlined in the interagency agreement is who will manage the waiting list for the program and how is that list organized. And there's no one right answer for how to manage the waiting list, but most states have found that what they assumed would work at the beginning of their process will need to be refined and tweaked over time. Waiting lists are typically managed by either the housing agency, the service or disability agency, or the state or local agency. And waiting lists are generally organized by either by property or by a city, county, or region. Waiting lists must take into account any preferences or priorities required by the state for the target population, if you have any. So next, we're going to talk about some important considerations for the waiting list during a referral to a property. So now you have somebody, you determined that they're eligible for the program, you selected them using your PRA tenant selection plan on your waiting list, and now they're ready to be referred to an owner. So a property has a vacancy, they notify the person who is usually typically the housing agency, but not always. So notified the program that there's a vacancy. And so now you need to refer that person or persons to the property. So the process of a referral to the owner, which is the property from the waiting list, is an important element of the 811 PRA program. Each state needs to determine the process for referrals and how to support the applicant to ensure a successful referral. Some important considerations for the waiting list include how many referrals to make to a property per vacancy. This is important because the priority of both the property and the 811 PRA program is to get a unit filled quickly. If only one person is referred to at a time, there could be a delay if that person cannot be found or is denied for the property. States must ensure that those people at the top of the list are ready for a referral to the property. This requires a lot of ongoing coordination between the partner agencies to communicate when someone is nearing the top of the list. Generally, the state service agency, either directly or through their local service agencies, must work with the applicant to ensure they are ready to be referred. This includes ensuring that they are interested in the property and that they have the required documents for referrals, such as proof of income and identification. Grantees need to consider who is responsible for communication with the applicant at the time of referral. If a person has been on the waiting list for a period of time, it will probably not be enough just to give them a call or email and let them know that a unit is available. Someone in the 811 PRA program needs to follow up with that applicant and ensure that they are supported and ready to apply for the unit. In many states, this is a local service provider, such as a case manager. However, many states have found that state-level staff need to regularly check in with the local service staff to make sure the referrals go smoothly and that the vacancies are filled in a timely manner. Okay, so now somebody has been referred from the waiting list to a property. And let's talk about the tenant screening at that point. So once an applicant has been referred from a waiting list to a property, the applicant will be screened for both eligibility for both program criteria, such as income, and for screening criteria of the property. The property can screen the 811 PRA applicant with the same screening criteria they use for other non-811 PRA tenants. For some properties, this screening at the property level includes rental history, credit, and criminal history. Grantees must approve the property's tenant selection plan and will know what that screening criteria that the property intends to use. The grantee also needs to ensure that the screening criteria is consistent with the 811 PRA requirements. The program partners can work with the property to lessen the credit screening criteria for the 811 PRA tenants since they have a rent subsidy. Some grantees have found that the 811 PRA applicants are being denied at the property level based on their criminal background. This is allowed as long as the denial is consistent with the grantee-approved tenant selection plan. However, there are things that grantees can do to assist applicants with this issue. Local service providers can do direct outreach to properties to build relationships between property managers and the service providers. This can assist the property to understand the types of services and supports that a tenant will receive during the tenancy and could make a property feel more comfortable accepting tenants with criminal backgrounds. In addition, all 811 PRA applicants have the right to ask for a reasonable accommodation request if they believe that their denial is based on their disability. Some local service providers do not know how to ask for a reasonable accommodation request and might be intimidated by the process. This request needs to include a request to reconsider the denial of tenancy and backup information of how the denial relates to the applicant's disability. Training may need to happen at the local level for how to complete reasonable accommodation requests. So now you have a tenant, and that tenant is ready to move in. So let's talk through that process. There are a few required steps. So the owner is required to complete a move-in inspection. Grantees can create or approve that move-in inspection form. The 811 PRA tenant can attend the move-in inspection, but is not required to do so. Next, the lease is executed between the tenant and the property. The property will determine the total tenant payment using the requirements of the HUD handbook, which is 4350.3. The property can charge a security deposit, but is not required to do so. The security deposit is allowed to be the greater of 1 month's total tenant payment or $50, whichever is greater. The local service provider coordinates services at this point and ensures that they have supports that the supports are in place for that tenant to be successful. So this is just like the grantee has ongoing program responsibilities. This is an ongoing program responsibility of the service agency to ensure that the services are continued to be available to the tenant. So those are our slides. And now we're going to have some time for questions. And I have invited two people who have graciously agreed to help me answer questions. They are from the Maryland 811 PRA program. I have two people from the Maryland Department of Disabilities. They are Christina Bolyard and Pat Sylvester. So my understanding is that they will now have their phone lines opened. Hello, Pat and Christina, can you hear me? Can you talk?
Yes.
Yes.
Hi, welcome. Thank you so much for joining us. What we're hoping to do now is to facilitate some questions, and Pat and Christina can help answer from their experience. They've been running a successful 811 PRA program for a few years now in Maryland. And Ellen is going to read off questions for us. So Ellen, do we have any questions to start with?
Yep, we have one question, so keep them coming, everybody. But somebody is wondering whether a property can charge a future tenant an application fee under this program.
No.
Did everybody hear that? No, you cannot.
Thank you.
Are there any other questions from folks? You can feel free to raise your hand, or you can type them in, or just something that you would like to chat about.
We've just got another question. Could you guys provide some examples of the types of regular meetings that you're having between the state agencies? Like what topics you're talking about, that sort of thing?
So Pat and Christina, I'm going to let you guys take that. What do you do in Maryland? What type of regular meetings do you do?
So we have a regular monthly meeting for our interagency groups. So the Department of Disabilities, the Department of Health, the Department of Housing and Community Development, and then some sub-agencies that still fall under the Department of Health. We all meet monthly to go over the programs that we have, or to go over the Section 811 program, and to give updates on, properties that are in the pipeline, properties that we're currently working with, issues that we're having with, any properties or tenants that we're currently working with or that are housed. And then we also meet quarterly with our advisory group. So that's a lot of other state agencies, including the partnership that we have for the 811 program.
We also
And I'm wondering, in addition to that, do you meet regularly with your local service providers? Or is that more of an as-needed basis?
We do a quarterly meeting with case management managers, the different agencies. We started off monthly and attendance wasn't very good, but we found that people wanted still to get together in person, so we do that quarterly. And then we do conference calls for the case managers who are involved with applicants for particular properties. And we find that people will attend those more regularly than sort of a generic meeting. So as we open a property a month or so before people would move in, we start doing a monthly conference call, and then it might become weekly as we get real close to move in, so that we can help case managers with questions they specifically have, or help them learn from each other.
So can you talk a little bit more about that? So what types of issues do you talk through? So if we have somebody on the line who hasn't yet had a new property, and they're kind of wondering what type of things they might talk through at a call like that, what are the topics that you cover?
So normally, I would like to back up a little bit even before we start those calls. So when we usually start talking to a property roughly about 6 months before we know that they're ready to lease up their property. And we'd go over tenant selection plans, paperwork for the application, documents to be collected, those sorts of things. We get as much of that information ahead of time so that when we start talking to the case managers, we can give them all of that information so that they're prepared in advance of working with their clients to get all of that stuff together. So it's even the property rules, because if anyone's gone through a lease signing process, the paperwork at the lease signing is overwhelming. And I think property managers are, I don't want to say they're robotic, but they're so used to, going through this whole process that I think it's very fast for them. And so a lot of times individuals miss things. So we go over as much of that stuff as we can in advance with the case manager so that they can give that information to their clients, so they're even prepared before they go in for that lease signing. We get a copy of the lease so that they know what they're going to process or what they're going to sign. We get utility allowances, the smoking policy, the pet policy, who the cable provider, the utility provider is at in that community. I mean, so much of that detail so that it's not so last minute when they go to, 2 days before they sign their lease, they have to find out who the utility provider is to get utilities in their name. But it's even things like making sure that they can get utilities in their name so that it's not a lease violation, making sure that they don't have an outstanding utility balance, and working through should they get renter's insurance. I'm trying to think if I'm missing. I mean,
part of it is that you have some people that are brand new at doing case management, or they do case management, but they're not used to transitioning people to housing. So to some extent, our calls, our quarterly meetings and our calls are designed to help the newbies and have also the seasoned people also help each other, answer any questions they have. Sometimes they get mixed messages from the property. Sometimes their client can't get out, or they can't get out to see the property because it might be in a jurisdiction they're not familiar with. Somebody else may have visited and they can share that information. It's an opportunity for them to vent, ask questions, and it's also our opportunity to encourage and nudge and push them and remind them of all the things they need to do, and that their work's not done when somebody signs their lease.
So a couple of follow-up questions for you on that. So how many people, when you have a vacancy, how many people do you refer to the property in Maryland?
We like to refer at least 2 to 3 people per unit.
And how do you find that is working?
It works very well just because you could have, let's say you had 4 units and you send 4 people, I'm going to say 85% of the time, all 4 people or one of those, people may not move for whatever reason. They go visit the property and they don't like the apartment. They don't like the neighborhood. They don't like transportation. They don't like that there's not, their health status could change, and they're not ready to move. So we like to do 2 to 3 so that we have a good group of people ready to go, so that it's not a delay in a property leasing up and getting all of their their units filled in a timely manner. We have people ready to go with paperwork done, interviews done, all of that stuff, so that and we let everybody know their number on the list, so that it's not, if there's 4 units and somebody's number 8, number 8 may not get the unit, but could get the unit if something were, to change. So we try to give as much of that information as we can up front.
So occasionally we run into problems where property can only process one person for a unit at a time because of how they do their ticks. And so we have to caution them and help them understand that if they're going to work that way, then they need to be cognizant that it could, if that person decides for whatever reason not to move forward, they can't just automatically jump to whoever they want to jump to. They have to take the people in the order that we approve them to be selected for the unit. Because sometimes when you refer multiple people, the person at the back end of the lease may actually get their paperwork in faster than the person at the top of the list. And so it does require us to manage expectations, both of the applicants as well as the property. And in the end, we basically will send the property a list saying, here are the 4 people you may offer a unit to. You may not offer the unit to person number 6 on the list unless and until we say you can.
Okay. And what do you have experience with if your folks that you referred have been denied at the property level due to the property tenant selection plan? And if you could talk a little bit about your process for that, and if you do reasonable accommodations and how you might organize those.
Sure. So we have a consultant on staff that assists us and case managers and their clients with writing those reasonable accommodations. And I would tell you that in a lot of situations we've had, almost all of our applicants have been able to put in that reasonable accommodation request and have been approved to move in by the property. There have been a few that did not submit reasonable accommodations because there was no nexus between their disability and whatever was on that background check that, we could, put in that reasonable accommodation. But we've been very successful with our consultant helping with those reasonable accommodation requests.
So when you say consultant, does that mean it's a state level staff person who's helping the local service providers create those reasonable accommodation requests? Is that what that means?
So we're the Department of Disabilities, and we actually have contracted with some outside folks who have experience and have worked in creating these programs. So they work under contract with the Department of Disabilities, and one of them has particular expertise in helping write reasonable accommodations. So she's also often the person we refer people to help. It's one of the tasks she does under contract with the Department of Disabilities. We could do it internally. We just don't have enough. I mean, we just use consultants as well.
Okay. I'm going to pause there and see, Ellen, do we have other questions that have come in? I want to make sure we get to those.
Yep, we have quite a few now, actually. So I'm going to start with a follow-up question around reasonable accommodation. Somebody's wondering if you could give an example of a successful reasonable accommodation that would relate to a disability.
Well, Pat or Christina, do you have a good example of from your referrals?
So what I would say to you is we've had a situation where someone with a mental health disability had past run-in with the police and had something on their record, and that criminal background came back, and the person was able to provide information that they had been through a court-ordered training, and they had been in therapy, and they were on their meds, and that the incident involved a time when they were having a conflict with a family member, and they weren't on their meds, and the property was willing to basically accept the reasonable accommodation. We've had situations on credit where someone may have bad credit or have a history of not having paid something, and can explain that the reason that rent didn't get paid is they ended up in the hospital and the rent went into arrearage, and they were able to explain the situation, and the property allowed the person with that credit history to move forward.
Thank you.
Great, thanks. We have another question here. Somebody who's wondering if the household member with the disability between the ages of 18 and 61 has to be the head of household, or could it be the spouse or the co-head?
I can jump in. It does not have to be the head of household. So the PRA program, the target population person, can define who their household is, if that makes sense. They don't have to be a traditional, like, husband and wife, for instance.
Yeah, so we have a situation where the target population, he is identified, he is the head of household, but in fact, he lives with his mother and siblings. But he's the head of household from our perspective, but doesn't necessarily live alone. His mother is his primary caregiver.
Thank you. We have another question here from somebody who's wondering if this program is able to pay for that security deposit that an owner might require a tenant to pay.
We don't do that.
No, so I can answer programmatically. So the PRA funds cannot be used for the security deposit. So that is something that definitely the local service provider should be aware of, and hopefully won't be a surprise, right? That's part of preparing somebody to move into the unit, is to get prepared for paying if the property requires a security deposit, making sure there's a source for that, making sure, you know, that's just one of the pieces that definitely needs to be planned for.
So maybe I misunderstood the question, but I thought the question was, there was one of your slides said that the security deposit is either the tenant portion of the rent or $50.
Right. Yeah,
but
whichever's greater.
The program could decide to pay a higher security deposit if it wanted to. I was responding to the fact that in Maryland, we limit the security deposit to the tenant portion of the rent, or $50. We do not provide any non-PRA funds or program funds to allow a property owner to have a higher security deposit.
Oh, I see what you mean. I thought the question was, and so what I was trying to answer is, does the PRA program itself pay for the security deposit? Is it eligible? And that's not an eligible use of the PRA funds. So if somebody needs to pay 1 month total tenant payment or $50 in Maryland, is that something that you help prepare your local service providers to make sure that that tenant has that security deposit?
Yes, so we would inform them of that amount that would be due. And for our individuals who are coming out of a nursing facility or an institution, their waiver program usually has transition funds that can help with that. For anyone else that's in, a situation that they don't have those waiver funds like that, some of our local community action network programs help with that. Some churches, we try to give as many resources to help assist them with getting that security deposit ready.
And so And just to loop back to make sure that, because we're talking about two different issues about security deposit. So what the 811 PRA program allows is 1 month of total tenant payment or $50, whichever is greater. And I moved back to that slide so you could see it. So some states have had discussions with HUD about if the property really wants more security deposit than that and feels uncomfortable with that, could they use other funds that the state may have access to. So I would say if you're with a state and you think that's an issue and you think that your properties that you're considering working with will be really concerned about the small security deposit, you talk to your TAC technical assistance lead, and they can tell you more about that potential option. But I don't want folks to get too confused about that. Okay. So Ellen, I think we're ready for the next one.
Great. Do applicants in the 811 program have to have verifiable income, or could they have zero income?
They
can, go ahead.
Well, I was going to say they can have zero income. However, we've had some properties that are a little more weary, I guess, of how things are going to be paid outside of rent and utilities so that they can be successful in the unit while they're there. I mean, it does raise issues, but it is not, they do not have to have income for our program.
Yeah. Typically, someone coming out of an institution may not have income when they initially transitioned. Eventually, their check will come to them. And so we've had to have some discussions with properties of understanding that it can take a month before the check gets transferred from the nursing facility to the individual. For people that don't have SSI or SSDI or any source of income, the real issue is how do they buy food? How do they do anything else? You know, do they have a means for actually successful tenancy? And that's part of what the supports and services you're supposed to be bringing to the table is supposed to be able to address. So yes, maybe they're getting food stamps. Yes, they've applied for SSI. Yes, there is some additional support that'll come so that the property becomes comfortable that that household can actually sustain tenancy beyond the rent subsidy. They still have to be able to pay their security, their utility allowance.
Thank you. That was great.
So we've got another question here from someone who's asking for some clarification around how much an 811 PRA tenant can be charged in rent. It sounds like they're working with somebody who's interested in starting to work, and the property owner told them that the rent would increase significantly. So could you just talk a little bit about the rental amounts that are charged?
Sure. So, oh, go ahead. I want Christina and Pat to answer if you guys have something. Go ahead.
I was just going to say, so their rent is going to be 30% of their household income. However, if they start working and they then become over income, well, their income could become over 30% of AMI.
Right, but her slide earlier on just said they can continue to live there and pay 30% of income. So it may be the person will always pay 30% of their income for rent plus utilities. And it is important for the person to understand that they will have to declare that increase in rent and that increase in income, and the property will redetermine their rent and make an adjustment. So they'll pay more and the rent subsidy for the program will go down. That doesn't necessarily mean that people should be discouraged from working. They still will have more. So if they make more income, only 30% of it gets earmarked for rent. They'll still have the other 70% for other costs.
Right, and so the property has to use the HUD handbook, which is 4350.3, to determine the total tenant payment. And so that is roughly 30%. there can be deductions to make it more affordable, for instance, for certain things that a tenant may have to have as an expense that are like a medical equipment, for instance. So there's a whole host of things in that handbook that makes it a little bit more complicated than 30% of your income. But it's important to note that that tenant has the right, as their income stays, if their income starts to rise, that they can stay in that unit. And you're right, it's just adjusted. They have to report that increase. So if they get a job and their income goes up, they have to report that every time their income goes up to the property management firm, who then would adjust their rent. And then let's say that their income goes up so much that they can now afford the regular rent, which is called the contract rent in the program terms. They can still stay in that unit and pay the contract rent. And it would still be, and they would only be asked to do that if it was affordable to them, which means that is about 30% of their income. So I hope that there's no property manager out there discouraging somebody from working if that's what they want to do.
So the other thing to keep in mind is that for many people with disabilities, their income stream and their ability to earn fluctuates a lot. They could be in good health, but a year from now could have a health event. So even though they may have good income and able to pay a significant amount toward their rent, a health event could change that. And so there are very many people that are going to want to stay in a unit that is protected by a subsidy, even though they may actually be earning more than you would anticipate.
Thank you.
Thank you.
So we've got another question, just asking for a little bit more clarification around the member with a disability. Could that person be a dependent on the 50059 form?
No, the person has to be 18 to 62.
So the person, there's a difference. There's like if they're a member of the target population. So each state determines who their target population is. And in addition to being a member of that target population, that list, I'm going the wrong way. They have to be, here it is, at least 18 years of age or under the age of 62, have a disability, be eligible for services. So that's the target population, and then the household combined needs to be extremely low income. I hope that helps.
Thank you. We have another question here asking, who is responsible if there are damages to the unit beyond the amount that the security deposit would cover? Is it the tenant? Is it the 811 program?
So the 811 program doesn't have an extra set of funds that would pay for damages beyond the security deposit. So there is no extra pool of funds. So ultimately, the property could be eligible for that or would be. I think, though, in that situation, that would be something that you would definitely want to have a conversation with if that situation arose with the state housing agency, the state service agency, to work through that situation. I don't know if Maryland, if you've had that come up yet, if you had damages above the security deposit.
No, but what I would say to you is that most properties probably have either in their tenant selection plan, their resident selection plan, or their property rules, something that addresses whether or not if the damages for a unit go above and beyond whatever a person's security deposit is, what their rights are to recover those costs. And those rules would also apply to an 811 resident, because I don't believe 811 has anything that says they can't do that.
Thank you.
Yeah, and I would reiterate that's typical. There's nothing in the 811 PRA program that would prevent them from moving forward with that, as far as I know. I would have to look at the lease again, but I assume that they could collect damages.
We've got another question here from somebody who's wondering if a potential PRA tenant is denied because of their criminal background or their credit, and you're working on submitting a reasonable accommodation, what's preventing that property manager from just moving on to the next person that you have sent their information to?
Well, that's a great question.
Hopefully, so we work pretty closely with the property. So if we know someone's working on a reasonable accommodation request and they're a higher priority than someone else that's being processed, and we don't have enough units to house them both, we would basically tell the property that they can't make an offer. And your reasonable accommodation request has to come in fairly timely, so you have to juggle that. Our experience has been typically, you know, if your reasonable accommodation person is high on your list to be housed, and you have multiple units, you may house other people into those units, just holding one for that reasonable accommodation request, and you nudge strongly both the applicant to get it in and the property to review it.
That's great. Thank you.
And another similar question, how do you handle it when a potential tenant decides that they do not want to move into the property that you've referred them to? Do they remain on the wait list? How does that work?
I'm going to let Marilyn answer. I'm going to jump in real quick. Is that every state, that would be something that would be a policy that would be in your PRA tenant selection plan, is you know, how you want to deal with that. So you could have something that says a tenant that could apply and reject 3 properties, for instance, or you could say they could reject as many properties as they want and continue to stay on waiting lists. So it's up to each state, but I want to let Marilyn answer about what their policy is for that.
We allow 3, but we do moan and cry. And when somebody turns down a unit the day before they were supposed to go in and sign a lease, so we have had that happen to us. But they can stay on the list.
Thank you. We've got another question here from somebody who's wondering, would it be possible, and I think this might vary state to state, but for someone to be eligible for the program who might be living in an apartment but is eligible otherwise in terms of having a disability and qualifying for services?
So yes, so it depends on the state's target population, right? Oops, somehow got out of that. Let me start from the beginning again. I wanted to get to the target population slide. So excuse me, I have a hard time multitasking. So this is the the target member eligibility as required by HUD is the first 3 bullets here. The age, having a disability, being eligible for services. And the 4th one is being a member of the target population. And that is dependent on the state and how the target population is defined in the interagency agreement. So for instance, if a state has as their only target population being some money follows the person, which are those people exiting an institution, then a person in an apartment might not qualify as a member of their target population because they're only serving people that are transitioning out of a nursing facility. However, if they are serving people that, you might have a state that has their target population of persons with serious mental illness. And let's say the target population is broad enough that they could be living in a lot of different scenarios. So they could be people experiencing homeless with serious mental illness. They could be stably housed. As long as they met the other eligibility as far as the program is concerned, they could, in theory, be living in an apartment and be eligible for the 811 PRA program. Marilyn, do you have anybody in your target population where that scenario happens?
Our second priority are people in substandard or at risk of institutionalization. So we may have someone who's living in something that's in housing that's considered substandard. We have a population pool that's called what we call generally eligible. So those would be people that are they meet the criteria, but they may be otherwise stably housed at the time. They can get on, they used to be able to get on the wait list. We closed it last March because we had so many. But we only get to them if we've gone through the 4 higher priorities, and it's unusual for us to get down to that group.
Okay, thank you.
And is there a place where participants in this webinar might be able to find their state-specific policies for 811 PRA?
Most states have a website that is dedicated to their 811 PRA program. I know Maryland, for instance, has a nice website where they've placed most of this information. The HUD Exchange website, and you can correct me if I'm wrong, Ellen, I believe has all of the contact information now for each program, each state. And you could, if it's not available on the website, you could certainly contact the 811 PRA program contact and ask for that information.
So DHCD, the Department of Housing, maintains Maryland's Section 811 website. So you can Google DHCD, and then when you get to their website, you won't be able to find it unless you then search for Section 811.
Ellen, do we have any other questions?
Yep, we have one more here. When somebody's living in an 811 unit and their income increases, what's the time frame in which they need to report that to the property owner?
I don't think I know that off the top of my head. I would have to look that up. I mean, it is essentially, you know, they need to report it right away, but I know that the HUD handbook has very specific time frame parameters of what that is.
I'm sure.
So unfortunately, I'm not going to be able to
do their lease move in. You know, if it's small, it's not as urgent. But you're right. Off the top of my head, I don't know. Clearly, you'd have
I think
to
part of what's important is that you can wait 3 months, but you will have to pay from the time you incurred the increase. So you will owe the housing provider for the months you did not indicate the increase.
Yeah, so it's a responsibility definitely of the tenant to notify the property of changes in income.
Thank you. We've got another question from somebody who's asking you to clarify that so they're saying, doesn't the owner have to perform the move-in inspection with the 811 tenant? This person believes that the handbook requires the tenant and the owner to sign the move-in inspection. Is that?
So that is a great question. So the 811 PRA program is governed, a lot of the regulations around it are in something called the cooperative agreement, which is a contract between the state housing agency or the grantee and HUD. And in that, it outlines the requirements of the move-in inspection. And the move-in inspection is not required for the PRA tenant, but the PRA tenant has the right to be there. And that was actually around since the beginning of the design of the program, because there was concern that the PRA tenants might find it too burdensome to be present at the move-in inspection. And so they wanted to be able to give them the option to opt out of it if they wanted to.
Thank you. We've got one last question. I think you already answered it partially, but just to confirm, somebody's wondering if a person was applying for a unit and some rental arrears that they owed from a previous tenancy were a barrier, would 811 be able to pay for those rental arrears? in order to help the person move in.
Right. No, the 811 funds cannot be used for that purpose. But that's a great example of the work that needs to go into getting a tenant ready to apply at the property. So that is something that perhaps the local service provider, maybe it's a case manager, can work with a tenant to make sure that if they do owe past bills due to the rental history, that they work on that, or perhaps come to an arrangement on past due bills. I don't know if Pat or Christina, if you have anything that you typically have seen in that situation.
Well, we require them to clear it. I mean, local resources case managers generally can figure out, or they can get on a payment plan. Sometimes that'll address the issue.
Thank you. And we do have one more question here. Is the full amount of a special claim affected in Section 811 PRA if an owner does not collect the full security deposit?
That's definitely a TRAX and DHCD question. We don't know the answer to that.
Repeat the question one more time for me, Ellen.
Is the full amount of a special claim affected in 811 if an owner does not collect the full security deposit?
Oh yeah, I don't know the answer to that question either. There might be somebody, I'm not sure who else might be on this from TAC that knows the answer to that question, but I don't off the top of my head. That would be something I would definitely follow up with your TAC TA lead if you had a specific question like that. And I do want to follow up with, we got somebody was kind enough to send me some information from the model lease, which is the lease that's required by the PRA program between the tenant and the property. And it says the tenant agrees to advise the landlord immediately if a household member moves out of the unit. I'm reading the list. If any adult member of the household who is reported as unemployed on the most recent certification obtains employment, or the household income increases by $200 or more a month. So that's the specific information that's actually in the lease. So hopefully that helps answer that previous question.
Thank you. We've got somebody here who is wondering how much time typically passes between a notification that a tenant has been approved to move into a unit and the actual move-in date.
That's a great question too. Marilyn, what do you guys have found is typical for your program?
Oh boy.
There is no typical. So often a person can be approved to move in and move in the next day. We've seen that happen with some folks that were homeless. Other circumstances may be somebody's approved to move in. They may be scheduled to sign a lease within a week or 10 days, that they might not actually, because they're leaving an institution or for whatever reason, move in right away. So the property is going to want the person to take possession of the property within 30 days, put something of theirs in the property so that in the unit, but we actually have a circumstance. Is that a 811 person that hasn't? We do have a circumstance right now where someone took more than 45 days, more has she actually, where she's resisting moving in. And we don't quite understand what's going on, and her case manager is working with her. So it's been much longer than we would like.
So that probably is an instance too of, it depends partially on your target population. I assume that a delay is perhaps more likely if somebody's transitioning out of an institution, because the coordination of services required, but since you serve multiple target populations, do you find that typical? Is that if somebody's transitioning from an institution, it can take a bit longer
It can.
to transition into you?
The one circumstance we currently have is not someone transitioning from an institution. It's somebody transitioning from a non-accessible unit to what would be accessible for her. So we don't quite understand what the situation is, and it is pretty unusual. So I would say most folks move in within 30 days of when they're approved, unless the property is really good and approves people very early in their process, so the units aren't available. Most of our units are new construction units.
Great, thank you. So Ellen, I know we're over time. Do we have any last minute questions?
No, it doesn't look like it. I think we're good to go.
Thank you. And I want to give a big thank you and shout out to the Maryland Department of Disabilities, to Christina and Pat. Thank you so much for helping me answer questions and providing your perspective. It was extremely valuable. And thank you to everybody that participated today. So that concludes our webinar, and we hope you will join us for our next one in 2 weeks. Thanks so much.
Take care.